If your NGO, trust, society, church, temple trust, mosque committee, or religious institution receives foreign funding, this update could directly affect you. The Ministry of Home Affairs has introduced major amendments to the FCRA rules. For the first time, the government has clearly identified which religious activities can be undertaken using foreign contributions. At the same time, it has clearly prohibited activities involving religious conversion. The amendments also introduce stricter compliance requirements, revised penalties, wider accountability, and new registration conditions. What activities are now permitted? What activities remain prohibited? Who will be responsible for compliance? And how can organizations avoid penalties under the new framework? Let's understand the new FCRA Rules 2026 in simple language. Why these amendments matter? The Foreign Contribution Regulation Act, commonly known as FCRA, regulates the receipt and utilization of foreign contributions by organizations in India. Any organization receiving foreign funds must comply with the provisions of FCRA and the related rules. For many years, questions were raised regarding the types of religious activities that could be undertaken using foreign contributions. The latest amendments seek to remove that uncertainty by creating a detailed framework identifying permissible religious activities and strengthening compliance obligations. What has changed? The Ministry of Home Affairs has introduced a dedicated schedule specifying activities that qualify under religious purposes. Organizations seeking registration or renewal under FCRA for religious purposes must align their proposed activities with the prescribed schedule. In simple terms, organizations will now need to clearly identify the specific religious activities they intend to undertake and ensure that such activities fall within the approved categories. This provides greater clarity while also increasing regulatory oversight. Permitted religious activities. The new framework recognizes several religious activities as permissible. These include construction of places of worship, renovation of temples, mosques, churches, gurudwaras, monasteries, and synagogues, maintenance of religious institutions, preservation of sacred and heritage religious sites, printing of religious scriptures, translation of religious texts, digitization and preservation of manuscripts and commentaries, religious education and moral instruction, study and research relating to religious philosophy and history, spiritual discourses and religious gatherings, meditation retreats, promotion of devotional music and cultural activities, preservation and documentation of indigenous and tribal faith traditions. The rules also permit facilities for pilgrims, including drinking water, sanitation facilities, and shelter arrangements at religious locations. Additionally, community-based religious initiatives such as dharamshalas, langars, annadans, and community kitchens are included within the permissible framework. The most important restriction. While the amendments permit several religious activities, they also impose a clear limitation. Activities involving religious conversion or proselytization are excluded from the permissible list. This means foreign contributions cannot be utilized for activities aimed at converting individuals from one religion to another. This is one of the most significant aspects of the amendment and reflects the government's policy approach toward foreign-funded religious activities. New registration requirements. The amendments also strengthen registration-related compliance. Going forward, registration certificates must clearly specify the exact purpose for which registration is granted, the geographical area where activities will be undertaken. Organizations will be required to identify the states or union territories in which they intend to operate. This means organizations must define their objectives and operational areas with greater precision. The scope for vague or broad descriptions has been significantly reduced. Introduction of key functionary. Another important amendment is the introduction of the term key functionary. The concept expands accountability beyond traditional office bearers. Depending upon the organizational structure, key functionaries may include directors, trustees, partners, office bearers, karta of a Hindu undivided family. Any person responsible for the management, control, or administration of the organization. This change broadens personal responsibility for ensuring compliance with FCRA requirements. Revised penalties. The ministry has also revised compounding penalties for certain violations. For example, where an organization exceeds the prescribed limit on administrative expenses, penalties may be imposed. The revised penalty may be 1 lakh rupees or 5% of the amount spent beyond the permissible limit, whichever is higher. This demonstrates a stronger enforcement mechanism and highlights the importance of proper financial controls. Practical impact on organizations. Organizations receiving foreign contributions should immediately review their registration certificates, objects and governing documents, religious activities being undertaken, geographical areas of operation, administrative expense ratios, internal governance mechanisms, compliance monitoring systems. Organizations should ensure that their activities remain within the approved categories and that all reporting obligations are fulfilled accurately. Key takeaways. The new FCRA Rules 2026 introduce a more structured and compliance-oriented framework. The amendments clearly identify permissible religious activities, prohibit activities involving religious conversion, expand accountability through the concept of key functionaries, require greater clarity regarding operational objectives and geographical areas, revise penalties for non-compliance. Overall, the amendments are designed to enhance transparency, accountability, and regulatory oversight in relation to foreign contributions. Conclusion. For NGOs, trusts, societies, and religious institutions receiving foreign contributions, these amendments represent an important compliance development. Organizations should carefully study the new framework, review their existing operations, and take necessary steps to ensure compliance with the revised rules. Understanding these changes today can help avoid regulatory challenges tomorrow. If you found this explanation useful, please like the video, subscribe to Corporate and Securities Law Compass, and share this update with professionals working in the NGO, compliance, and legal sectors. Thank you for watching. Disclaimer. Viewing this video or accessing the content on this channel are free and does not create any professional, advisory, or client relationship between the speaker and the viewer. The content is shared solely for general educational and informational purposes. The speaker is a member of the Institute of Company Secretaries of India, ICSI. However, the information provided in this video should not be construed as professional advice, consultancy, or opinion under any law or regulation. Viewers should not rely solely on the information provided in this video for making legal, financial, regulatory, or compliance decisions. Any person intending to rely upon or act on the information contained herein should independently verify the relevant provisions of law and, where appropriate, seek professional advice from a qualified professional. The speaker, the Institute of Company Secretaries of India, ICSI, and any organization or listed company with which the speaker may be associated shall not be liable for any direct or indirect loss, damage, or consequences arising from reliance on the information provided in this video or channel. The content shared on this channel is based solely on publicly available information, general legal provisions, and academic discussion of corporate and regulatory frameworks. The speaker confirms that no unpublished price-sensitive information, UPSI, confidential information, or proprietary information of any listed company or organization has been disclosed or discussed in any video or content on this channel. The views expressed in the videos are personal academic interpretations for educational purposes only and are not connected with or derived from any confidential information obtained through employment, professional engagement, or association with any listed company or organization. Nothing contained in this channel should be interpreted as market advice, investment advice, or insider information under the applicable provisions of securities laws, including the SEBI Prohibition of Insider Trading Regulations 2015. Viewers are advised that the information shared is purely for general educational awareness and should not be relied upon for investment decisions, trading decisions, or regulatory compliance without consulting appropriate professionals and official sources.